Hi, everyone. I'm Dan Rozansky. I'm moderating this panel. I'm a partner at Stubbs, Alderton, and Markiles. I'm a partner in the litigation group. My specialty is business litigation, privacy, data breach, trade secrets, and entertainment. Those are my areas of focus. I want to introduce our other panelists, Heather Antoine, Brian Levine, and Marc Polansky. Heather, do you want to introduce yourself?
Sure. Hi, everyone. I'm Heather Antoine. I'm also a partner at Stubbs, Alderton, and Markiles. I wear dual hats at the firm, so I am the chair of our trademark practice and also, for purposes of today, the chair of our data privacy and security practice. And I'm happy to be here.
And Marc?
Yes, hi, everyone. My name is Marc Polansky. I'm the Chief Legal Officer at Seed Beauty. We are a incubator for cosmetic brands located in Oxnard, California. I've also, I'm one of those rare attorneys that have jumped back and forth between firm life and general counsel life a number of times. So I've also got litigation experience on coverage issues, litigated the wildfires, and now I'm back in-house again dealing with makeup.
Dealing with wildfires and makeup. And Brian, can you introduce yourself?
Yeah, sure. Pleasure to be here. My name is Brian Levine. I'm Managing Director of EY's Transaction, Cybersecurity, and Data Privacy Group. So we focus on cybersecurity and data privacy in the context of mergers and acquisitions, divestitures, restructurings, that sort of thing. I joined EY about a year ago from the U.S. Department of Justice, where I was a cybercrime prosecutor in the computer crime and intellectual property section. I also served as national coordinator for all 300 cybercrime prosecutors around the country. Prior to that, I was an assistant attorney general in the New York Attorney General's office's Internet and Technology Bureau. And prior to that, I spent about 10 years in big law firms, including Morrison & Foerster in Palo Alto, better known as MoFo, and Paul Weiss in New York, better known as Paul Weiss. Pleasure to be here.
Thanks, everyone. Today, we're going to walk through a hypothetical cyber incident to understand how companies should be preparing for and responding to cyber incidents. The incidents are entirely fictitious. I want to note that there's a Q&A button, and we'll be taking questions. If you submit them online, we'll try to get to them after we go through the more formal part of this. Before we jump into the hypothetical, I want to talk to each of the panelists about what you do in advance of an incident. Preparing for cyber incident or data breach begins before an incident ever occurs. So let's talk about some of the steps that a company should take before the breach ever occurs. Marc, let's start with you. As in-house counsel, what do you think companies should be doing before a cyber incident or data breach occurs?
Sure. So there's a number of actions you want to take. Some of them will be orderly, and some of them basically you want to be doing all at the same time. But the first thing you want to do is you need to map your data. If you don't know where their sensitive information is, you can't protect it. And at the end of the day, you're going to want a written document. You're going to want to know all the repositories. You're going to want to have an inventory of the information within those repositories. You're going to want to assign an owner or manager over that data. And then you're going to want to classify the sensitivity of that data. And then with that document, you can then start putting controls in place. And I believe the best control is always the least amount of access. So people should only have access to things they absolutely need to do their jobs. Some of that will be software and programs that you're going to want to, your IT department is going to want to put controls over, because many of these programs have open access to anybody who wants them. You're going to want to limit that. But then also, you're going to want to identify those people that need it and give them access. You're going to want to think about password access. You're going to want to think about dual authentication, depending upon the sensitivity of the information. Everybody should be aware that when you're talking about trade secrets, the trade secret is only as good as your protection around that. So if you're not protecting that information, you'll basically lose the right to call that information a trade secret. After you've assigned privileges, you want to go ahead and monitor them regularly. At least once a year, you want to audit that. And anytime you hire somebody on new, you're going to want to make sure that they have access to only what they need. When people exit, you're going to want to make sure you've turned off their access to programs. If people transition into different roles, you're going to want to reevaluate what information they need access to. Speaking of exiting, you're going to want to create an exit process, and you're going to want to follow that every time. So that means coordinating between HR and IT, and when somebody is being terminated, they're at the same time, all their access is being taken away, so that if they're disgruntled, they don't come back and do something untoward towards your information. The other thing is you want to develop your security policies. Does your firm or your company have a BYOD policy? Are they bringing their own devices to work? If so, you need to have your employees sign documents. You want to be able to brick their phone if they've got company information on it. You want to be able to cut off their access, and because it's the employee's phone, they're going to have to agree to that. You can't do it on your own. So you need some planning around that. If the company is issuing laptops or issuing phones, you're going to want to put controls around that. Typically, a lot of people like Apple products. I don't like Apple products as much because it limits the amount of control a company can have over those products. But if you've got laptops and you've got particularly sensitive information, you want to maybe consider disabling the USB ports on there so people can't plug in USBs and take information that way. You want to design your system such that people are saving documents and saving their work on their system. So that means you want to have VPN set up. You don't want people to be able to store documents on their hard drives, on their computers, on their laptops, and all of that should be laid out within your employee handbook. And then you also want to have NDAs with your employees. It should be a condition of employment. If you don't have one drafted, you may want to seek outside counsel's advice on this, because you want it broad, but you don't want it overly broad, such that in states like California, where there's a right to work, where that agreement will be considered null and void because somehow you're affecting the employee's ability to work after he leaves your place of employment. You need training. A lot of these attacks happen from outside of your company, so you want to make sure that you've got regular training of your employees for phishing and scamming and hacking and everything that goes down with people trying to infiltrate your system. You want to have document retention policies in place. You don't want to have to protect information that you don't need, and that again is going to take a lot of work from IT, from all of the departments, identifying what documents you need, how long you have to keep them for compliance purposes, and then also for operating your business.
Mark, one thing that I want to add from a litigation perspective is that it's really important to make sure that the employees are actually signing the NDAs and employee manuals, even though there's an argument to be made that people are bound by it regardless if they sign it. Makes it a lot easier if there's ever an issue to have the people sign them. So make sure that you're doing that. Heather, so as outside counsel to several companies, what's the role of outside counsel when a company is creating an incident response plan or preparing for a cyber incident in advance of a problem?
Yeah, I mean, so obviously I'm biased when I answer this question in that I am outside counsel, but I always tell people, think of your outside counsel like the quarterback of the team. You have various positions that are going on, you have various plays that are happening, but the quarterback is really the one that has to initiate, they should manage, they should coordinate all of the various players. And the reason for that, and it's something that we talk about in the legal world often, and I will probably mention at least 50 times today, is attorney-client privilege. the importance of outside counsel being involved in this is key, and not just being involved in that you're CCing outside counsel on emails. There's a lot of arguments that have been made that that is not enough to provide privilege that's required here. And what I like to say is don't write plaintiff's exhibits for them. You know, make sure that we are at all times protecting all of the great work that Marc just mentioned, right? So all of this information and policies on remote access, on passwords, on encryption, on employees, all of that, work together with your outside counsel to make sure that that is being developed in a protected manner, so that we don't necessarily have to provide everything to the other side. Now, 100% privilege is impossible and it will generally be challenged, but the more involved outside counsel is in the entire process and with the coordination of the process, the better off you're going to be. As far as the incident response plan is concerned, I like to say take a step, actually one step out of that, and consider all of the cyber policies and really making sure that a complete audit is being conducted. And so that all of the policies that Marc mentioned and everything that, you know, all the steps that are being taken are accounted for. I think that's what's really important here.
You talked about being the quarterback as outside counsel of the incident response team. Who are the members of that team that you want ideally to be on that team?
You know, I think it depends on the size of the company and the company's needs. So you can have a $25 million company that only has 10 employees. And in that case, do all 10 people need to be on the team? Probably not. But if you have a $25 million company with 100 employees, let's talk about maybe who needs to be involved in that point. Generally speaking, I always say, you know, you want the CEO or operations manager, whoever it may be, and or both. You obviously want general counsel if there is one. You want the head of IT. If there's an information security officer, you want that person as well. I don't know if I mentioned the head of HR, but the head of HR should be involved. And then the head of marketing, because marketing often controls a lot of data and knows where all the data is going, and sometimes doesn't get looped into things. So in the event that all of those positions are filled, those are the people you want involved in the process and on the team.
Thanks. So Brian, you come to us with a law enforcement background. Is it ever too soon to get law enforcement involved in preparing for a cyber incident or data breach?
I do come from a law enforcement background, but unlike Heather, I am not biased in favor of law enforcement because I'm no longer law enforcement. So I can speak frankly, but you know, let's be honest here. If somebody breaks into your house, the first thing you're going to do is call 911. So why is it different if somebody breaks into your company? Law enforcement probably shouldn't be far behind. And I know, you know, if you go to outside counsel who hasn't been part of law enforcement, they will often be reluctant to get you involved with law enforcement because there's a parade of horribles that they think could possibly happen. And, you know, while anything's possible, in my experience, having been the national coordinator for all of the cybercrime prosecutors across the country, I didn't see during those 7 years any of that parade of horribles ever play out in any instance.
But are you contacted, but is there ever a scenario where in advance of an incident, you're actually getting law enforcement involved? Is there a role?
Yes, yeah, absolutely. Because if you have a breach and you just call the FBI's main number, you may not be overly impressed with the results. You know, if you've ever contacted the phone company because you have a question about your bill, for example, you may find that you're sitting on there on hold for like an hour, and then finally somebody gets on and they're not actually helpful. And in the end, you end up in a worse position than you were before you called the phone company. And I'm not saying anything in particular about the FBI or any of the other investigating agencies, but you're going to be in a much better position to involve law enforcement and to get effective help if you develop a relationship in advance. So that's the main thing I would say. You want to develop contacts with law enforcement in advance. And one of the best ways to do that is to join InfraGard, which is FBI's industry law enforcement association group. And you can go to regular meetings and you can meet local cyber agents and get their contact information and develop a relationship. So if anything does happen, you can quickly get them involved. And then once you do have their information, you have the relationship, you want to include their contact information in your incident response plan.
So I know that you're involved sometimes in NDA due diligence, M&A due diligence. If you're representing the acquiring company, what are you going to want to know about the target company's cybersecurity preparedness in an M&A deal?
Yeah, well, cybersecurity is a huge risk in an M&A deal, and it's a huge risk for two reasons. First, some of the risk comes from the target. What is their cybersecurity like? Are they taking best practices in terms of cybersecurity? Are they already breached? What systems do they have in place? How much is it going to cost you to remediate and improve their cybersecurity organization? But there have been numerous instances where M&A has resulted in huge breaches. Some of the most famous examples are the Marriott Starwood breach, where Marriott acquired Starwood. Starwood ended up being breached. It moved over to Marriott. Marriott got breached, ended up costing over $150 million to Marriott. Similarly, with the Verizon Yahoo deal, Verizon through oath acquired Yahoo. Yahoo was already breached and ended up costing Verizon over $350 million. But we see on a regular basis many less famous instances than that. So that's the risk from the counterparty. But then there's risk from the transaction itself, and this risk affects both parties. And that's because during a transaction, you have increased visibility, you have increased distraction amongst employees, and you have insiders who, once the transactions are announced, might be leaving involuntarily or voluntarily, and they're going to be distracted and potentially malicious as well. So there's a lot of risk around this, and what we've seen is that the risk has increased considerably during COVID. The FBI is reporting a 300% to 400% increase in cybercrime during COVID based on the number of complaints to IC3.gov, which is the Internet Crime Complaint Center. And what we're beginning to see is that a number of our targets are getting ransomware between sign and close. In other words, as soon as the deal is announced, both parties to the transaction get pummeled with cyber attacks, and frequently the target is infected with ransomware. So we've developed techniques to try and mitigate that risk. But it really goes to the most important thing around M&A and cybersecurity diligence is it's really important to use a third-party expert to do this, both because they're going to have a lot of experience at identifying the hidden risks that you wouldn't necessarily be able to find by just asking the usual basic questions. But also, you want to be in a situation where if there is later a breach, you want to be able to say, look, I didn't do this myself. I used an independent third-party expert, and they indicated that the transaction could proceed. There weren't any red flags. They provided some recommendations, and we moved forward on those. And what else can you expect us to do? And I'll tell you, as a third-party as a former regulator, there's really not much more you can ask an organization to do in that situation.
Thanks, Brian.
Dan, can I mention one quick thing?
Yeah.
I know you want to keep the ball moving here, but I think it's really important when we're talking about getting people involved beforehand. We talk about getting, making those connections with law enforcement, making those connections with the third parties. You also want to consider everyone else that you need to make a connection with as well. So do you need a PR team that's on standby in the event something happens? Do you need forensics? And that should all be done beforehand so that in the event of an incident or a breach, it's not a scramble.
Yeah, that's a good point. A lot of times when I'm dealing on the litigation side with a breach or a theft of trade secrets, whatever it is, I want to work in conjunction with a crisis management PR team, because a lot of bad news can come out very quickly and people get panicked, and it can be an existential event for your company. So it's important to have that PR piece in place. I want to get into the hypothetical, which will be a springboard for us to talk about we've talked about what you do in advance of there ever being a problem, but we want to get into, okay, there's a problem. What do you do now? and how does that carry out? So here's the hypothetical. You're general counsel to ABC AI. It's a technology company specializing in artificial intelligence powered software. The head of IT comes to you and says that a new logging and monitoring tool the IT team is piloting alerted the team to the fact that Dr. S, an employee in the research and development department with a PhD in computer engineering, has downloaded 400 files to what appears to be his personal laptop. The company's policies prohibit downloading company information to personal devices. The head of IT wants to know what to do. Mark, what, if anything, do you ask the head of IT? And what do you tell the head of IT to do?
Or first thing I ask them is, where's your incident response plan? And let's look at that, because if it's a proper plan, there should be all different scenarios laid out and covered. But the first thing I want to know is, what do we believe was taken? Was it trade secret, or is it PII of employees or customers? Because that may dictate whether I'm involving insurance under a cyber policy or not.
By PII, you want to just clarify what you mean?
Personally identifiable information, someone's name, address, and then also either account information or credit card information, something that can damage that person if it gets out and is publicly known.
And that's because it's treated differently under the law, correct?
That's correct. That's correct. There's personal information, and then there's personally identifiable information. And by the way, when I was talking about data mapping, everybody who's operating in California under the CCPA or CPRA now, they should be doing that anyway. So there's a lot of reasons to be taking these actions, not only just to prevent data theft. Once I've identified or asked the IT to identify what type of information was taken, then we can start looking at the next steps. I want to know how much information was taken. 400 documents of highly sensitive documents could be fairly important, and I would probably want to involve outside counsel right away, because as Heather mentioned, you want to keep the attorney-client privilege. And as general counsel, you're often doing both business work and legal work, and those lines get blurred very quickly, and you want to maintain that privilege. So I would absolutely contact outside counsel at that point. And then we'd probably start working through the incident response plan and talking about whether we need forensic experts or not, whether we need to conduct interviews. If so, how do we conduct those interviews? You don't want to tip somebody off if you think they're taking your information. You want to be able to prove it. You don't want them to dump it all. So there's a lot of moving pieces that you want to coordinate with your outside counsel.
So you're not immediately running to Dr. S and asking, what's going on here? What have you done?
Not at all. As a matter of fact, I don't want Dr. S to know what I know. Rule of litigation. Try to keep what you know secret from the other side and learn as much about what they know. It might be that there's nothing going on. Maybe you talk to Dr. S's supervisor and you find out that he's going to be in the hospital and needs access to his work. I would argue that should have been known up front, and we still may not want to give him access to it on his personal computer, but there could be different reasons for why that information was taken. You want to ask those people who you can trust, because again, word gets around very quickly. Ideally, again, if there are interviews involved, you want to be interviewing multiple people at the same time, so nobody's going back and forth and checking stories. You don't know if Dr. S is operating alone or in conjunction with others. So these are all things that you have to consider.
Thanks. Brian, is there a role for law enforcement at this stage?
Yes, there could be. So, in terms of law enforcement, bringing in it's going to depend on where, what this stage is. If you've gotten far enough into your, first you're going to usually start with your internal investigation. At some point during the internal investigation, you might involve a external vendor as well. But if you've gotten to the point where you think it's pretty likely that there's a potential crime here, and so by potential crime, I mean, potentially a violation of the Economic Espionage Act in terms of theft of trade secrets or attempted theft of trade secrets. It could be a breach of the Computer Fraud and Abuse Act, could be a wire fraud situation. But you're usually in these situations with these insiders, you're usually focused on the Economic Espionage Act. And getting law enforcement involved early can be pretty important because law enforcement can preserve digital evidence often within 24 hours of the time they're brought in. So for example, usually in most situations, the people involved in trade secret theft and other insiders are communicating using their personal email with their future employer, for example, or with their co-conspirators or with their girlfriends, whoever's involved. They're usually communicating over their personal email or a social media account. They're downloading things to cloud storage. And law enforcement, through the Electronic Communications Privacy Act, has the ability to preserve digital evidence just by sending a letter to any of these providers, to Gmail or Facebook or Dropbox or any of these. And then, to follow up and actually get the items, they may need a search warrant, but they can preserve it right away. And the other thing they can do is potentially execute search warrants on a person or their house. So, I've had instances in which corporations have thought they had a trade secret theft case on their hands, contacted FBI. They were able to execute a search warrant against a potential defendant, who was in the airport about to leave to go to China, and were able to take many CDs of thousands of gigabytes of information. So it made a huge difference. So what I suggest is before you go out and seek a TRO, a temporary restraining order, or do anything like that that would notify the target, the employee, that they're under investigation, I would get law enforcement involved and just ask them to preserve digital evidence. And then as soon as you can, once you're confident that things have been preserved and nothing's going to get destroyed, then you go out and you seek your TRO or take what other steps you want to take on your own to preserve your position and protect your intellectual property.
And if not law enforcement, you had mentioned an outside vendor, which I think is a great idea. Sometimes you're not going to get law enforcement involved, or you may not have control over them. But if there's a lot of outside vendors there that can, while they don't have the same reach as law enforcement, can act immediately and help you with the preservation process.
Yeah, well, and in fact, sometimes they have more reach than law enforcement. When I was in the DOJ, I prosecuted a big trade secret theft case. And the victim hired one of the big four accounting firms to do the inside investigation, in part because they were international and the theft involved both the US, Austria, and also China. And this big four firm was able to get key evidence from China that couldn't have been obtained otherwise, including by law enforcement, and was able to present enough evidence to have the insider arrested in Austria on his last day of work. So getting involved the external vendor can be really helpful.
Thanks. So Heather, as outside counsel, what are you telling the company to do at this point?
Take a breath. Generally, when this happens, the first thing that everyone does is forget all of the preparation that was put into place. So everything that we just talked about in this last section, where we went through the incident response plan and all of the policies, immediately goes out the door. And so my first thing is, let's get everyone back into place and let's remember that we have a plan for this. And, we implement the incident response plan. So it could be getting the forensics team into place. It could be reaching out to law enforcement. Obviously, as general counsel, I would like to be the one coordinating both of those aspects for the reasons we've mentioned, which is, attorney-client privilege. You also, in a weird way, want to make sure that you have, if you're going to get both law enforcement and an outside team involved, that they play well together. Because I've been involved in situations where the outside team very much does not want law enforcement involved, and that can be a problem if as a company you've made the decision that law enforcement should be involved. So all of that really needs to kind of happen smoothly, and you want to make sure a couple of other things aren't happening that seem obvious but that people forget. One, don't delete anything. So there are logs that need to be kept. There's information that needs to be stored. And so let's say there was a ransomware attack. And so the first thing people think about is, okay, let's wipe everything clean and start over. And we have these backups over here. That's a problem. Don't necessarily do that. And then you also want to think about, what are the communications we're putting out? Is something an incident or is it a breach? Because that terminology ends up becoming really important. And is this something we're prepared to tell the outside world about or not? So the pace of this should be very deliberate, very steady. You have an end goal, which is let's figure out what happened here. And we definitely don't want to panic along the route.
What legal issues are you worried about at this point? What do you see on the horizon? You have this.
Yeah, I think it's the issues that both Marc and Brian discussed. So we have potential issues regarding trade secret theft. So, what was taken? Is there a theft of trade secret? But we don't want to necessarily jump to that until we know a little bit more. You also have potential issues regarding, whether these files contain personal information. And if they do, does the information that they contain trigger potential notifications in the US and internationally? And those are very different standards. When we look at notification in the US, we're really determining on a state-by-state basis whether something qualifies for notification. Internationally, we have, we're governed by a number of laws. The EU is probably the one that's triggered the easiest, and notification is required in more cases in the EU than, and on less information than you would have to notify here in the US. So that's another one of those situations where immediately what I like to do is I start a chart and we start tracking, what's potentially affected here, and you work with your forensics team because they've done this before, you've done this before, and you just want to make it through the process without any assumptions. With one caveat, there are pre-breach notification letters that are sometimes required in various states. California is one of them, and you want to make sure you don't have to send those out.
Thanks. Let's get into the middle of the incident now. We think we've gotten our arms around things. We've started the investigation, and the IT team has gone through the old logs and discovered that a total of 5,000 files have been downloaded by Dr. S to his personal laptop. The files contain information regarding Dr. S's cutting-edge work on an AI-empowered technology that allows users to alter their appearance during Zoom video conference calls. The IT team has also identified that a number of related files have been sent by Dr. S to an email address associated with universities in China. The head of IT also tells you that he remembers that Dr. S had taken a 1-month leave of absence a few months ago, and according to what Dr. S told him, the purpose of the leave was to allow Dr. S to return to China to care for his aging parents. When the head of IT looked at the logs, he was able to determine that the vast majority of the 5,000 files were downloaded by Dr. S just before his leave of absence. So, Marc, what directions are you going to give your IT team in terms of monitoring Dr. S and more generally blocking the ability to download or send large files externally?
So given that I've been told by IT what he's taken, how much of it he's taken, and when he took it, I have already contacted outside counsel. And at this point in time, if I haven't yet, I'm going to want to identify and speak with law enforcement. As Brian said, hopefully you have those connections beforehand, because sometimes law enforcement comes in and they want to take over everything. If you have those relationships beforehand, you can kind of manage that sometimes a little better. But I do want to consider locking Dr. S out of taking any further documents if there's other valuable documents there. And I want to weigh that and balance it against Dr. S becoming suspicious that he's now being monitored. So you really have to play it by ear. And again, hopefully you've got a concerted plan with outside counsel and forensic experts and law enforcement.
So you've not made the determination yet whether to terminate Dr. S. You're consulting with an outside breach consultant. You're consulting with outside counsel, with IT, before you make that decision.
Yes, to some extent, you don't want to terminate right away because you really lose a lot of control and power over that investigation. As long as Mr. S doesn't know he's being investigated, you have a better shot of getting more information. Once he's been terminated, he knows that something's up and he's probably destroying things, trying to get out of the country, doing any number of things. So I don't believe I would terminate. Sometimes you want to put employees on a leave of absence while you're investigating, but at this point in time, in my mind, it's too early to terminate.
So Brian, this is starting to sound really bad. You've got somebody potentially sending trade secrets to China, to Chinese universities. And I'm sure, people are thinking, okay, now's the time to contact law enforcement, but what's the downside to doing so?
In reality, I don't think there is a downside to doing that. I hear all kinds of horror stories from lawyers, but I don't hear any actual stories. I mean, like, Marc just said law enforcement might take over. But like, what does that actually mean? They're not going to physically put some yellow tape and say, stay out of your company. I mean, it's a very minimal involvement that the FBI would typically have. They're going to want, they're going to need to talk to you. They're going to need to know what happens. Probably if there's a forensic analysis that's been done internally by the company or externally by a third party, they're going to want an image of what's already been copied. And they're going to have to learn, over time, they're going to have to figure out what it is that you think was stolen. Why do you think it's valuable? Why do you think it's a trade secret? But I really don't see a downside. There's this concern that they're going to take over the litigation or take over. In general, what I would train prosecutors and agents to do is preserve the evidence that you need to preserve. So that would be, anything that's evanescent, anything that could disappear right away, do it quickly, and then tell the outside counsel or the victim to go ahead and proceed with whatever they were going to do. Because you guys had the victim is in the best position to protect their own interests. And in fact, if they don't go ahead and bring a TRO or, they take no action, they rely entirely on the FBI, there's going to be an argument later by the defendant that weren't taking reasonable measures to protect the trade secret. You didn't really care about them. You're just leaving it to law enforcement to be pro bono counsel. So then, what I suggest law enforcement do is just continue investigating covertly in the background and see what happens with the civil litigation. If the civil litigation provides sufficient relief, if it goes forward and resolves everything, great. Maybe there's no need to bring a criminal action. Or you're getting evidence typically from the civil action, from the discovery, and you can see whether you think it rises to a criminal level and how strong the criminal case would be. Because in a criminal case, the case has to be proven beyond a reasonable doubt, which is a lot higher than in the civil case, a higher burden. And there's a lot of mens rea requirements, a lot of proving what the defendant had in their mind in a trade secret theft case, which is difficult to do beyond a reasonable doubt. So, there are a lot of concerns people have, but in my experience, when people and companies have actually brought in law enforcement, they're very thankful that they did, and they don't usually have complaints about it.
If law enforcement's asking, Marc is the general counsel for ABC AI or Heather as outside counsel for ABC AI for further information from the company, further documents or digital data, what should they just hand it over? Or should they require a subpoena or other kind of warrant?
Yeah, in my experience, some companies do that and some don't in terms of require a subpoena or a search warrant or something like that. Now, assuming that the victim has proper banners and consents in place that make it clear that all the information on the computers belong to the employer and that the employer has the right to turn it over to law enforcement, I don't think it really makes much of a difference whether you request legal process or not. It can't hurt from your perspective to request, a subpoena. So if you're concerned that, the victims, whoever the victim organization is, their policy might not be clear enough that they're entitled to all these documents and they can do what they want, then feel free to ask for a subpoena. A search warrant is generally not required in this situation. It would only be required, under unusual circumstances where, because the Fourth Amendment doesn't require it, but sometimes particular statutes might. So unless there's some particular statute that's applicable, you should be okay with a subpoena.
Heather, you had talked about the impact of PII or personal identifying information. What if there is no PII and after contacting the FBI, an investigation's opened into the conduct and it's determined that Dr. S has been providing the Chinese government with trade secrets? What do you do?
Yeah, I would actually hesitate to make the decision that there's no PII yet, because, and of course, as a data breach attorney, this is what I'm focused on personally. However, I would say at this point, it's a really, really good idea, if it hasn't been done already, to bring in the litigation team. So, and Dan, you and I have actually done this year together, where an incident occurred at a company. We weren't sure what was happening. Potentially there was a trade secret aspect of it, and potentially there was a breach aspect. And so I called you in, and then you and I worked together to kind of determine what the steps moving forward are. So as far as the trade secret side is concerned, I'm actually gonna surprise you as the moderator and throw this back at you and say, what are your thoughts on that topic? But before I do that, I do want to mention, the reason I say I don't want to give up on whether a breach of PII has occurred here yet or not is because in these 5,000 files, there is likely personal information. And that information has to be assessed by a forensics team to determine whether we are required to notify or not. Until we do that, I don't like to remove myself from the equation, although I love to remove myself from the equation in the event there's no PII, because that's fabulous, and then you can deal with all of it. So Dan, I will pass that one to you.
So what I would do is, the first thing I would do is I would immediately assess whether this is whether there's a risk to the company if this doesn't stop now. If the horse is already out of the barn, that's one thing. But if this seems like it might be ongoing, or if it seems like now that the horse is out of the barn that somebody else can use this information, the top thing on my mind is whether or not I need to be going into court as soon as possible to get a temporary restraining order and a preliminary injunction to stop further access to information, further dissemination of information, and the further use of information. And so, I'm working in unison with you. I'm working in unison with inside counsel. I'm working in unison with outside consultants, with whoever I can to gather information, to understand the scope of the problem and how I can nip it in the bud from a litigation perspective, if that's what's best for the client.
Yeah, and I'll throw in one other thing here is, we're talking about technology that alters the appearance. So we need to make sure that the company is not collecting biometric information, because that could also cause a problem here, right? That's a different level of sensitive personal information that we would have to account for. And biometric information is currently being regulated at both a state and a city level. San Francisco has biometric laws at this point. So you just have to tiptoe around this stuff a little carefully before we decide we're in the clear. Let's just focus on trade secrets. Okay, so now let's talk a little bit further down the line after the incident. And after contacting the FBI and investigate at Brian's suggestion, an investigation is opened into Dr. S's conduct.
the investigation finds Dr. S has been providing Chinese government agents trade secrets from ABCAI. An indictment and arrest are on the horizon. So, Brian, if the company reports an incident like this to the FBI, what can they expect the FBI to do? And if the government brings a case against Dr. S, what will the company's further involvement be in the prosecution?
Yeah, so I mean, in general, what the FBI would likely do is get the basic facts, preserve digital evidence. Likely they'll investigate covertly in the background, as I mentioned, while the civil lawsuit proceeds. And then they'll figure out whether a criminal prosecution is appropriate, given all the factors that the government, both the FBI and the prosecutors, would consider under those circumstances. In terms of what the company's role will be with respect to the FBI or whatever law enforcement is involved, typically it would be the FBI. The company's going to have to provide the government with documents. If there's a civil action, they're probably going to be providing whatever they're providing to the defense and providing whatever they're receiving from the defense. But they're also going to have to explain what was stolen, the technology, because if it is a trade secret, for example, there's no other way the FBI or the government is, the prosecutors are going to be able to understand the technology, because the only people who really understand it are going to be the company whose trade secret is and the defendant who stole it, and the defendant is not going to explain it to the government and explain why it is a trade secret. So they're going to have to explain the technology and the measures it used to protect the technology. And likely, if there is a trial at the end of the day, they're going to have to provide witnesses for the trial, because even once the company explains to law enforcement why the trade secret is a trade secret, the FBI case agent can't get up there on the stand and testify to those facts. You'd need the engineers or the experts from the company to explain the technology to the jury and explain why it's a trade secret. So, they're going to have some level of involvement throughout the process. But what I would say is, if you get the government involved, if you get the FBI involved and they're able to get the trade secret back for you right away, from law enforcement's perspective, that's a win. So even if there isn't a prosecutable case at the end of the day, preventing or mitigating a theft and the damage that would result from a theft is probably more important than having a prosecutable case. So hopefully you'll get relief regardless of which direction it goes.
I just want to remind people to submit their questions. Brian, also in this scenario, we're dealing with an individual who's acting on behalf of a nation state. How should companies think about cybersecurity protections when it comes to nation state actors?
Yes, so when it comes to nation state actors, especially if we're talking about trade secret theft or other intellectual property, it's mostly the same protections that you're thinking about in terms of cybersecurity. Generally, they're just less likely to work to be effective with a nation state. They may still be, but when it comes to nation state trade secret theft, for example, it turns out that they tend to rely heavily on insiders to do this. So you want to have a significant focus on preventing insider theft. And there's a lot of things you can actually do for that. First, you can actually have an insider theft plan, and a lot of companies that have a lot of intellectual property and trade secrets and protections, trade secret theft protection, do indeed have insider theft plans that they update regularly. Then, as Marc mentioned earlier, it's really important to limit access for employees and contractors to what they actually need to have access to. And there's technology called identity access management systems, IAM, that can be very complex, but can be implemented across a corporate environment to ensure that people only have access to what they're supposed to have access to. Another tool that's very helpful is a data loss prevention solution, or a DLP, which basically limits, one of the chief features of it is it limits what an employee can do with information that they get access to. So for example, it limits the different ways in which they could exfiltrate it. So they might be unable to access Dropbox to download it there. It may prevent use of a USB drive so that you couldn't take the information that way. It may prevent you from emailing certain files that contain trade secret information or that contain PII or that contain anything to a personal email account, like your personal Gmail account. You can set it up, and Mark mentioned this earlier as well, you can set it up so there's automated deprovisioning of employees and contractors. So as soon as the HR has made the determination that the employee or contractor is done, the deprovisioning of their access happens automatically. And then another thing that Mark mentioned that I think is important for insider theft protection, which is relevant to nation states, because that's what they like to use, is the exit interview. It's very effective in sometimes preventing information from leaving the company, from alerting the company that there's something suspicious going on there because the way they answer questions is concerning. And it certainly, can dramatically improve a civil case or prosecution against these employees after the fact. So for example, if one of your question in the exit interview, and this is in writing, is, you're asking the person you're reading the question out loud, which is, please sign here to indicate that you have taken no documents or information from the company that isn't listed here specifically and that you haven't gotten approval from your supervisor to take. You want to make it really black and white in that exit interview. So they're not interpreting whether it's confidential or proprietary or trade secret. You want to say they're not taking anything other than what they've specifically listed there. And another tip is if you do that electronically, then you can, if you do it right, you can create an automatic wire fraud charge there if they lie about it. And you can tell them that. You can say, we set up this system with a server here, and you're going to sign here electronically, and we do it that way. Because if you're lying on here, there's a wire fraud charge, and that's a 20-year maximum. So please be careful before you lie on filling this out. So there are definitely things you can do.
Heather, what should the company do after an incident like this?
I think so. Assuming that we've now taken care of the notifications, and those have all gone out to whoever they needed to go out to, whether it's the supervisory authorities in the EU or the states here. Then we have to do what I think is probably one of the most crucial things is a gap analysis. What are the lessons learned? What did we miss? What could we have done better? And this kind of goes back to the first thing we talked about, which is, we have all of this and we have a plan, but where did that plan go wrong? And maybe it didn't go wrong. Maybe everything was perfect, but, shit happens. If that's the case, then that's okay. But let's figure out what the lessons learned are. I think, the data loss prevention tools that Brian's talking about are really important. Access is crucial. People should not have access unless they need it. Both Shopify and Instacart this year had to send out breach notifications because employees of one of their vendors accessed information that they should not have been able to access. Nothing was taken, nothing was stolen. However, both of these companies had liability and they had to send out these breach notification letters. So we really need to make sure that we're tracking where everything lives. And this is the very first thing that I think Mark said, which is the data map. Where does everything live? Who is it being shared with? Who has access to it? Let's track all of that. And then the last thing that you have to deal with is after the investigations wind up, after the notifications have gone out, what is the backlash? What is the fallout of this? So have we been contacted by any regulators? Has, Massachusetts often likes to follow up in particular and ask for a written information security plan. Do you have a WISP in place? All of that, making sure that we've now cleared all of the rubble and that we're even more prepared in the event something like this should ever happen again.
Yeah, I'll say from a litigation perspective, I always like to do the sort of postmortem in these kinds of incidents. And one of the first things I tell people to do is look back at the documents. Are they all signed? Should they be enhanced? oftentimes the confidentiality provisions and NDAs don't say what you think they say. So I think it's a really good time to go make sure that your house is in order. So the next time this happens, you're not trying to jump over the same hurdles that you didn't think were there in the first place. Mark, as GC, you're probably typically not dealing with nation states and insiders feeding information to nation states, but I think we see more typically that it's an insider who's taking information because he or she is going to a new job and wants to get a head start. So you're probably not going to call law enforcement. What are you doing when you find out that somebody's taking information to a competitor?
So typically you want in your handbook some verbiage there, letting the employees know that when they do leave, you are going to be contacting their future employer and letting them know that they are subject to confidentiality provisions. It could be as simple as sending out that letter to the future employer. If you are concerned that information was taken, that it's sensitive, and that you could be damaged by it being shared with another employer, you want to start thinking about declaratory judgment actions, TROs. And again, that's something that will be probably managed with the outside counsel you've been working with throughout this incident.
Thanks. Let's go to Q&A. Here's a question. What limitation should be placed on an employee's ability to back up company information on their own cloud account, and what or should the company do to stop this from happening?
So, yeah, so they shouldn't be able to do that. First, the policy and procedure in the handbook on use should be very clear that that's not an acceptable use. And so that's the first thing. And there, as Mark mentioned and Heather mentioned, there should be training on that. It shouldn't be expected to just read and sign the policy. They should be regular annual training on that. And then there should be technical blocks to make it harder to do that, whether it's a data loss prevention solution like I described or some other technical block that prevents them from going to Dropbox or Google's cloud storage site or any of the other top 10, 15. That's frequently how trade secret theft ends up occurring, or it's part of the common route. So a number of DOJ cases, things were brought to Dropbox, for example, the Alenikoff case out of the Southern District of New York, a controversial case. But one thing that isn't in controversy is that the insider downloaded the source code for the high-speed trading system to Dropbox. So, if that had been eliminated, he would have to figure out another way to do it.
Here's another question. Are there regulations related to recordings of public meetings offered by ventures seeking investment? What about private meetings between investors and companies via the platform arranged by the investment platform? I'll take this on first, which is, are there regulations related to recordings of public meetings or private meetings? There are recording statutes that vary by state, and I think most states are considered one-party consent states, meaning that as long as one party to a conversation consents to its recording, they can go ahead and record any conversation. That's as opposed to no party consents where somebody puts in a bug or a mic or something and walks away, then they're not a party to that conversation. Other states like California, two-party consent states, it's a complicated issue to determine whether or not consent is required in these circumstances. I would say in the public meeting, you may be okay because there's probably not a reasonable expectation that you're not going to be recorded. In the private meeting scenario, I would say that you need to get the consent of the speaker and other participants in the conversation. Does anybody have any other thoughts on those topics or that topic?
I would just say, regardless of the statute or the situation, if you have a little red recording light on, like we've got now, at least we can see, I can see right now in Zoom, then you're probably okay recording the meeting.
I disagree with that, but that's okay. We'll debate that another time.
I don't have anything to add to that question, but I do have one thing to add that I want people to keep in mind to the prior question, which was, you know, more on the protection side. If you happen to be an Apple-based company, which many companies are, just be careful with AirDrop, because that can sometimes be another way that information can go, you know, past where you want it to go. So you always want to make sure you're accounting for all of the various access points, and that's really important here.
Okay. As a follow-up question to the one about recording, somebody asked how to deal with a situation where one person's in California and another person is out of state. In other words, California is two-party consent, another state is one-party consent. I would assume that you're bound by two-party consent laws, and California has a Supreme Court case that deals with that issue. Somebody asked about cyber insurance and whether cyber insurance policies cover the costs and work related to cyber breaches, to data breaches.
I can discuss that. It depends on your policy, but typically if it's a data breach involving PII, it will be covered. And that's one reason why you want to notify your insurance company early on in this process. If it's trade secret, it's probably not going to be covered, and you'll have to cover that as a company.
So for Heather and Brian, do you find that most companies buy cyber coverage?
Yeah. Oh, go ahead, Heather.
I was going to say yes, and I think all companies should. You know, in years ago, it was a little bit cheaper, and it's definitely gotten more expensive as time has gone on because there's been more claims that have been filed. But I think it's a non-starter. Every business should have cyber insurance and really understand the policy that they're getting, because sometimes there are exclusions that unless you read it, you may not know that that's there, or there could be an extremely high deductible. Maybe there's $100,000 deductible. You just want to read the policy, make sure it's the right fit, but it's very important in my opinion. Brian?
Yeah, just to add to that, the vast majority of instances we've seen, the company, even smaller, newer companies do have some cyber insurance, but they're consistently underinsured in our experience. And one way you can get a sort of a general sense of what your coverage level should be, Chubb has a tool on their website where you can put in certain information, the industry you're in, the annual revenue, number of PII records, and it will estimate what the cost of a breach may be. And that can give you some guidance in selecting a coverage amount.
Thanks. Here's another question. I'm building a website that will serve accredited investors that will complete an application confirming their qualifications as well as stating investment interests. Are there any regulations regarding safeguarding this data provided by investors? How about data collected from third parties?
I mean, the short answer is yes. It's probably covered by a number of different laws and regulations, both federally and state. There, you know, all information is pretty much at this point governed by something. So what I would recommend doing is, you know, again, we go back to the data map. Let's look at what you have and then figure out what we need to do to protect it. But yeah, it's definitely going to be covered. I hope that answers the question.
Thanks. Is it a good idea for a company to have a separate agreement with employees regarding the use of electronic equipment, or is it okay to just have the statement in the company's employment handbook? I'll give you my view is I would have a separate policy. I think it's really important, and sometimes employee handbooks are so dense that it may lose the impact by having it buried in there. So I would say have it in a separate agreement. Does anybody have any other thoughts?
I think it's generally a good practice.
agree. If you do have it in your handbook, then at the end of the handbook where the employee signs off on everything, you want a specific provision in there that they read and understood the electronic hardware policy as well, and they sign off on that as well at the end of the handbook.
That's a great idea to have different provisions that like that if you're going to include it in the employee handbook to make sure that they're signing and acknowledging various provisions. You see this a lot with arbitration provisions, but you know, I would say that these are probably even more important. Brian, you were going to say something?
Yeah, I was just going to say that it's a good point, and to take it in another direction, if you have a very lengthy employee handbook and they're just signing it at the end or even throughout, it's a much less effective exhibit if you're showing it to them in court and saying, you signed that you read and understood this 100-page document, because everyone in the jury is thinking, yeah, right, he really read and understood that 100. So I think it's more effective in terms of setting yourself up to have short policies that people sign each policy separately.
Here's one last question. What are some of your recommended best practices for drafting the master services agreement for a client vis-a-vis a vendor that anticipates and prepares for a potential data breach? Since this says hi Heather, I'm going to let you answer this one, Heather.
Hi. So yeah, I think every MSA at this point should probably have some anticipation of two things here, right? One, what is the personal information that's potentially impacted? And then two, in the event of a data breach, who's responsible, who has to tell who, when do they have to tell who? And sometimes when you're dealing with larger companies, such as, you know, let's say your Salesforce is one of your outside vendors, they have set template data processing agreements and they have set template MSAs, and that's what they want you to use. And you can only negotiate to a certain amount, if at all, depending on your size of your contract. But if you're dealing with other companies that are potentially smaller, you always want to account for this information, because you want to make sure that all of the personal information that they are accessing can only be accessed for certain purposes, and that's required by the CCPA and other laws, and that they can't use it for their own purposes, for, you know, so to speak, or they can't share it with someone else and sell the data. So you want to make sure that that's all explained. I typically tell both the attorneys inside my firm and in-house counsel that I work with, send me these documents. I don't need to review the entire MSA, but what I want to see is the data provisions and any provisions that relate to data, whether it be indemnity in the event of a breach or any sort of breach provisions, because it's important that those are not just glossed over as okay, well, that's good, it's accounted for, but really, what are we accounting for?
Nice. So last thing I'm going to ask each of the panelists, in 2 sentences or less, what's your key takeaway for people watching this? Let's start with you, Brian.
I think the biggest thing about data breaches is try and prevent them rather than focus on what you're going to do afterwards. So that should be absolutely something you do. It's a response plan, et cetera. But the biggest thing I think you can do to help prevent these is to have a thorough cybersecurity assessment in advance and find out where you stand, where your maturity is, and what you can do to improve your cybersecurity posture, so you hopefully don't have to be answering these questions.
What about you, Mark? What would you tell people to take away from this?
I would agree with what Brian said. An ounce of prevention is well worth it. The other thing I would say is, once you've put in your incident response plan together, audit it. Run tests against that, and actually, you know, it's usually part of a DRP anyway, so you want to make sure you can roll forward, roll back, and actually institute everything that's in there. You want to make sure when you've got your legal contacts that they're current and they're up to date. So you can't just set it and forget it. You have to stay up with it.
And what about you, Heather?
Yeah, I'm along the same lines. I mean, it's going to be prevention all the way here, and making sure you have everything lined up and tested. Run through a couple fake breaches. Make sure that everyone knows, you know, if it's 2 a.m, who are we calling first, right? Are we waking up in-house counsel? Or are we waking up outside counsel? who gets notified, right? So it's all of that prevention work that really will help down the line.
Yeah, I'll agree with all of you. Here, an ounce of prevention is worth a pound of cure. I think all of these preventative measures that you could be taking in advance are a lot cheaper than if you find yourself in litigation. So I think that's really helpful. So I thank all of the panelists for all of your insight here. I think this is really good. And instead of just telling bad war stories, you gave a lot of practical information. So thank you to everybody.
Thanks. Bye, everyone.